All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan.
While already on bond for a felony case, Mason appears back in court for contempt. The judge listens quietly, checks the file, then coldly revokes bond after learning about a new felony charge. No emotional reaction, just controlled authority and immediate consequences.
People of the State of Michigan versus Mason David Kozlowski. It's filed 25-7106FH. Counsel, you want to state your appearances beginning with people?
Anthony Julian on behalf of people.
And James Gilbert acting as the MIDC arraignment attorney.
All right, and Mr. Kozlowski, it's alleged that you are in contempt of court for violating the conditions of your bond by being involved in criminal activity on or about February 7th, 2026, while on bond for this case. It looks like that criminal activity is an allegation that you committed a felony malicious destruction of building. It looks like there are charges that have been filed in this county. Has Mr. Kozlowski been arraigned on those new charges?
Yes, he has.
Okay.
That's my understanding.
Now, Mr. Kozlowski, the allegation that you're in contempt of court by committing that crime while you're on bond, in the case you have in front of me, you have the right to have a hearing where that contempt need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer. Mr. Gilbert represents you in this case, and he's here for the arraignment as well. If you are found to be in contempt, you could be jailed for up to 93 days, fined up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond at any time. And finally, it looks like you'd already entered a plea recently, and sentencing is scheduled in March, and post-plea bond is entirely discretionary with the court in any respect. Mr. Kozlowski, do you understand the rights that you have and the penalties that you face?
Yes, sir.
Okay, Mr. Gilbert, how's he wish to plead?
At this point, he'll stand mute and request a hearing.
All right, so we'll enter a plea of not guilty as to the contempt. And he's scheduled for sentencing on March 17th at 2:50 in the afternoon. We use the same date and time to schedule it for a status conference on the pending contempt. Of course, the main issue is going to be whether, sorting out his level of involvement with that alleged criminal activity, because that would constitute post-plea misconduct, and he has a sentence agreement that could be implicated thereby. So I don't know whether we'll be ready at that point in time or not, but we'll at least initially schedule it then.
Sure.
And I guess since he already entered a plea and now it's alleged that he's out there committing more crimes, I would intend to remand him, but I'd hear from counsel if he had any pitch to make otherwise.
Well, Your Honor, I'd ask that possibly the court reinstate his bond. I do believe he knows that by any type of involvement, not acknowledging any type of involvement, but that he has a lot hanging over his head. I don't think you're gonna have any issues with him coming to court or even being involved or close to any other type of criminal activity. I'm assuming sitting in the holding cell for the last 5 days is probably an eye opener, and I'd ask the court to take that into consideration.
Okay, Mr. Juliet, people's position.
I would ask that he be remanded. He's on bond to this court for a property crime. He's on bond in Emmett County for a property crime. So whatever safeguards have been put in place as far as bond are not working. So I guess that it should be revoked.
Yeah, Mr. Kozlowski, you pled guilty to me very recently for being in possession of a stolen car, and I didn't cancel your bond at that point. We don't like to do that in a property crime, wait till we get to sentencing, but now you've been charged, you pled to a 5-year property crime, and now in the meantime, while you've been out on bond, you've been charged with a 10-year felony property crime. So again, you've got all the rights to have a hearing, and you've got the right to a trial on that new charge as well. But I think especially post-plea, as a matter of my discretion, I'm going to cancel your bond and you'll sit in court till your sentencing. You'll sit in the jail until your sentencing.
Oh, Your Honor, in this matter, I'd ask that I be assigned to the case.
Oh, yes. Okay. Yeah, and I think you already are, so.
Okay, that's true. The bond, yeah.
Let's go off the record here. To the next file. All right, we're back on the record, and up next, we've got an arraignment in People v. Michaela Stribic. It's two file numbers, 25-6975FH and 26-7131FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
And James Gilbert acting as the MIDC arraignment attorney.
All right, and Ms. Stribic, we've got two file numbers. First, I'll go with the oldest one first. In 25-697.
Michaela, a habitual offender, stands before the judge after absconding probation and picking up new charges. The courtroom tone turns firm. Without hesitation, the judge revokes bond in both files. No sympathy, no second chances, just strict accountability.
A pending case, that's the other case we have. And then I'm here to arraign you on a new allegation that you violated probation, and there was a bench warrant. And that alleges that you violated your probation by engaging in a violation of criminal law, by engaging in behavior that maliciously destroyed a building located on E Street in the city of Sheboygan. In the probation file, you have the right to have a hearing, where that would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer. And although the rules of evidence don't apply at that hearing, you have the right to present evidence in your own defense and question any of the witnesses presented against you. If you are found to be in violation for that reason, I could revoke your probation and sentence you on the 8-year maximum absconding habitual third. In the probation file, do you understand the rights that you have and the maximum penalty that you could face?
Yes, sir.
Mr. Gilbert, how she wish to plead in that file?
She's going to stand mute at this time, Your Honor.
Okay, we'll enter a plea of not guilty on her behalf in the probation file. I note that she's already scheduled for a status conference on the probation violation that was already pending on March 18th at 11 a.m. It was a special date and time for Mr. Kareem Johnson, who represents her in the case. So we can just add this as another violation at the same date and time, March 18th at 11 a.m. In the 26 file, that's a case that Ms. Stribic has not yet been arraigned on, and that's been adjourned again, that arraignment to March 18th at 11 a.m. with Mr. Johnson. Ms. Stribic, in that case, I have a warrant that alleges that you're in contempt of court for violating the conditions of your bond by being involved in criminal activity on or about February 7th while on bond for this case. It looks like that alleges that you engaged in a felony malicious destruction of building and have been charged with that with a habitual fourth notice. In the contempt, you have the right to have a hearing where your contempt would need to be proven beyond a reasonable doubt, right to the assistance of a lawyer. And if you are found to be in contempt, I could fine you for up to $7,500, jail you for up to 93 days or both. Also, if you're violating the conditions of your bond, I can revoke that bond. Mr. Gilbert, do you know how she wishes to plead in that?
She's going to stand mute also.
All right, so in that file, we have the arraignment scheduled on March 18th at 11 a.m. We'll add to the docket a status conference on this pending contempt at the same date and time. And Mr. Johnson already represents her in those files. He can represent her at that hearing.
Excellent.
And Ms. Goodrich, people's position with regard to any release between now and then?
Oh, Your Honor, I'd ask that her bond be revoked. This is her second probation violation on the first case, and then a bond violation on the second case. She does have 6 prior misdemeanors, 5 prior felonies, all but one was committed in the last 10 years. I think at this time her bond should be revoked.
Mr. Gilbert?
Your Honor, we ask that the bond still stay in effect. I do believe that she understands that there's quite a bit hanging over her head and that any additional even allegations of any improper activity would be very detrimental to her. So I'd ask the court to let her remain on.
Well, while Ms. Stribic's been on probation for the absconding, she was charged with a new felony crime, the possession of methamphetamine, and I did not order her to be held at that time, allowed her to be released on her own recognizance. And now it's alleged that she's committed another felony. this destruction of property. So I think, under those circumstances where there's been 2 alleged felony crimes committed while she's been on probation, I think at this point I'd be remiss not to cancel her bond. So in both these files, I'll order that Ms. Strivick be remanded to the care and custody of the Sheboygan County Sheriff and held in the Sheboygan County Jail without release until further order of the court.
Thank you.
Thank you.
The next one, the others. Go off the record for a minute. All right, we're back on the record and providing public access in the courtroom and also online. And we have an arraignment in 2 files, People v. Camden Hepner. It's file 24-6921 and 25-7087. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
And James Gilbert acting as the MIDC arraignment attorney.
All right, so Mr. Hepner, I'll do the probation file first here. You're on probation to me for malicious destruction of personal property over $1,000, carries a maximum of 5 years in prison. And it's alleged that you are in violation of your probation in 2 counts. Count 1, that on or about February 7th, you possessed alcoholic beverages. That would be a technical violation, and the maximum penalty for that would be 15 days jail. Count 2 alleges that on or about February 7th, you violated the criminal law by causing destruction to a residence on E Street in Sheboygan. That is not a technical violation, which means that if you were found guilty of that or admitted to it, that I could revoke your.
Already on probation and recently pleading guilty to a weapons felony, Camden now faces a new $20,000 property destruction charge. The judge's tone turns ice cold. Bond revoked immediately. The message is clear. Repeated crimes mean jail is coming.
It's not proof beyond a reasonable doubt like at a trial. It's just more than 50%. The rules of evidence don't apply at that hearing, except as to privilege, but you are allowed to present evidence if you wish, and you're allowed to question any of the witnesses presented against you. And you have the right to an attorney, including an attorney at public expense if you requested and qualify. Do you understand the rights that you have and the maximum penalties in the probation file?
Yes.
And Mr. Gilbert, do you know I wishes to?
Yes, he'll stand mute at this time and request a hearing.
Okay, we'll enter a plea of not guilty on that file. And before we set a hearing, let's talk about the other one. So in file 25-7087 FH, Mr. Hepner has recently pled guilty to a weapons felony. Sentencing is set for March 17th at 3:10 in the afternoon. In that file, Mr. Hepner, it's alleged that you're in contempt of court for violating the conditions of your bond by being involved in criminal activity on or about February 7th while on bond for this case. And it looks like what's attached to that is an allegation that you have committed felonies of malicious destruction of a building over $20,000 with a habitual notice and lying to police with a habitual notice as well. Now and has he been arraigned on that new charge?
Yes, this morning.
Okay. Now, Mr. Hepner, in this file, if you are found to be in contempt of court where you admit to it, I could jail you for up to 93 days, or I could fine you up to $7,500 or both. Also, if I believe you're not complying with your bond, I can revoke the bond. And finally, because you recently entered a plea in this case, bond is entirely discretionary with the court. Do you understand the rights that you have and the penalties that you could face in this case?
Yes.
And how does he wish to plead to that?
Still stand mute also.
Okay, we'll enter a plea of not guilty on the contempt. What we'll do then is he's currently scheduled for sentencing in the 7087 file on March 17th at 3:10 in the afternoon. We'll add in that file at the same date and time a status conference on the contempt. And in 6921, we'll add at the same date and time a status conference on the pending probation violation. And then Ms. Goodrich, what's the people's position with regard to any release between now and then?
Your Honor, at this time, I would ask that bond be revoked and probation bond not be set. For the probation case, it was a malicious destruction of personal property case, and now he's being accused of a second one while still on probation for the first one. And then as to the bond violation, it was a public safety crime to start discharging a firearm out of a car in a populated area down Straits Highway in front of Fernelius, and then has once again involved the community by a malicious destruction of personal property charge.
Thank you, Mr. Gilbert.
Your Honor, I believe Mr. Hupner, excuse me, knows that quite a bit is hanging over his head. I've been Camden for a while, and I don't believe that you'll see him involved in any type of other activity that could jeopardize his freedom and or the plea language that we have setting out there, or the possibility of getting additional time based off of his probation. I would ask the court to consider leaving him out on bond until the 17th, when it's determined what will happen then.
All right, thank you. Mr. Hepner, I've previously told you some of my concerns about your behavior, and I've talked with you about how important it is for you to put a good foot forward for your sentencing. And, you know, I don't know whether you're guilty of this. I don't want you to tell me anything about that. And there are new felony charges for that. So I don't know whether we're going to end up needing to adjourn this out to see what happens with that. I don't know. But at this point, I think bond is entirely discretionary in the weapons case. And the prosecutor's right, you're on probation for malicious destruction of property and now charged with a similar crime that's even a greater maximum penalty. Under those circumstances, Mr. Hepner, and I'm also taking into account in the case you're on probation for, I had to revoke your bond because you were committing more crimes while on bond. And so for some reason, you haven't yet decided to slow down. And I guess I want to tell you, Mr. Hepner, I really do not want to send somebody as young as you to prison, but you're working it really hard. You're trying really hard to go. So I'm going to order you to be held in both files without bond until further order of the court and in the jail. I want to tell you how you behave in the jail matters. Okay. We'll get reports that sometimes people commit crimes back there, but even stuff that's short of a crime, that's misconducts, I'll know about that. So, I mean, I've told you this before and it didn't get through, but you really are on the bubble. So toe the line. All right, we'll see you on March 17th at 3 tonight. All right, that'll conclude our afternoon docket. Be in recess.